If you've been arrested for domestic violence and you think you're safe because the victim is on your side, stop right there. That assumption is one of the biggest mistakes that you can make, and it can mean the difference between walking away free or living with a conviction. Today, I'm going to walk you through 3 critical ways that the victim's efforts to help or get the charges dropped can actually backfire and make things far worse than either of you ever imagined. My name is Veronica. I'm a domestic violence defense attorney here in California, and I help people throughout the entire state put their cases behind them so that they can enjoy their lives and their freedom. By the end of this video, you'll know exactly why DIY is not the way to go when it comes to domestic violence cases. And make sure to stay until the end, because number 1 is the most common mistake that people make, and it's the one that catches everyone off guard. All right, so let's jump right in. Number 3, the victim submits a statement to the DA or the police after the arrest but before court. So one of the most common ways that people try to fix a domestic violence case is by having the victim reach out to the prosecutor or the police before the first court date. And this usually happens because the victim believes that they can explain the situation, show their support for the defendant, and convince the authorities to drop the charges. And it does seem logical, right? If the victim says they don't want to press charges, then the case should go away. But unfortunately, that is not how the system works. And this well-meaning effort often makes things much worse. So let's get into an example of how this plays out. Fran and Dan get into an argument. The police show up and Dan gets arrested even though Fran didn't want him to be. Fran feels terrible. She loves Dan, she bails him out of jail as soon as she can the next morning, and she thinks that if she can just explain everything to the prosecutor, then this will all go away. So Fran writes a heartfelt letter to the DA, the district attorney, the prosecutor, asking for the charges to be dropped. Now here's where things take a turn for the worse. The prosecutor, let's call him Steve, he's at his desk and he's working through a mountain of police reports. Domestic violence cases come across his desk every day, but something about Dan's case stands out. Fran's letter. And a letter like this, written by the victim without an attorney involved, without an attorney's name on the file, is rare. And prosecutor Steve, when he sees this, his ears perk up. This is a red flag. Now, in the letter, Fran says that she loves Dan, they're engaged, and they plan to go to couples counseling. She even claims that she was the aggressor that night. She thinks that this will convince Steve to drop the charges. But here's how Steve actually sees it. First of all, to Steve, the timing looks suspicious. The letter comes about a week after the arrest. To Steve, this isn't Fran being honest. It's Fran feeling pressured now that Dan is back at home. In his mind, Fran probably told the truth when the police were there, when Fran and Dan were separated, and she felt safe telling the truth, but now she's recanting because Dan is influencing her. And this reinforces the prosecutor's belief that Dan is dangerous and that Fran needs protection. Now, another thing that stands out to prosecutor Steve is that Fran admits to being the aggressor. And by saying that, Fran's letter confirms that there was, in fact, a physical altercation. This is evidence against Dan. Now, Dan's defense attorney in the future won't be able to argue that nothing happened. And worse, with no visible injuries to Dan, it's going to be difficult for Dan to argue that it was self-defense. So Fran's statement is going to make it much harder to fight against these charges. And prosecutor Steve also notices this letter that's from Fran without an attorney involved signals that Dan will not hire an attorney, because prosecutor Steve knows one thing for sure. No competent defense attorney would ever allow Fran to submit this letter. If she's genuinely on Dan's side, then Fran would be in contact with whatever attorney Dan has. So to prosecutor Steve, this means that Dan isn't going to lawyer up. And that's a green light for him to move forward with aggressive charges, likely a felony, because he expects Dan to plead guilty quickly without a fight. Now, Steve goes back to the police report. He sees photos of bruises on Fran's arm, sees nothing on Dan, and now Steve feels even more confident that Dan is guilty. And before the day is over, he files felony charges against Dan. All because Fran thought that she was helping. Now here's the bottom line. Do not try to fix this on your own. If the victim wants to help, they should not under any circumstances be submitting letters on their own, making statements, or trying to contact the prosecution without an attorney reviewing it. It's far too easy to say the wrong thing, even if you have the best intentions. And to end up making the situation far worse. Now that you see how reaching out before court can backfire, let's talk about another common misstep that happens in court, and one that often makes everything worse. Number 2, the victim shows up at the first court date to try to get charges dropped, but it doesn't go according to plan. Now, one of the most common assumptions people make is that if the victim shows up to court and asks for the charges to be dropped, then everything will work out. But unfortunately, this approach, well meaning, almost always backfires. And it often makes the situation worse for not just the defendant, but also the victim. So let's jump into an example. Ben and Jen are a married couple with 2 kids. They have a 3-year-old and a 5-year-old, and life has been stressful for them. They are sleep deprived, overwhelmed, and constantly juggling responsibilities. One night, things boil over into a loud argument, and a concerned neighbor calls the police. Before they know it, Ben is arrested for domestic violence. But Jen doesn't want this. She loves Ben, and she just wants the charges to go away. So she decides to take matters into her own hands and shows up at Ben's first court date to clear things up. And here's where things really go wrong. Jen tries to talk to Ben's court-appointed public defender, assuming that they can work together to get the charges dropped, assuming that the public defender will be happy to talk to her. But the public defender shuts her down immediately, saying, "I represent Ben, not you." And he only speaks to Ben for about 30 seconds because he is overwhelmed with all the other cases. Now, they don't get to talk to a public defender before court, so this is the only time that either one of them have had to have any contact with the attorney representing Ben. Jen feels brushed off and frustrated, but she is determined to fix it. So next, she tries talking to the Prosecutor Steve. She catches his attention in court and explains that this is all a misunderstanding, and she does not want the charges pursued. But Prosecutor Steve is even more dismissive and cold, telling her it's not up to you, and then turning back to his other files. Now Jen feels emotional, defeated, angry, but things are about to get even worse. When Ben's case is called by the judge, Prosecutor Steve asks the judge for a criminal protective order to prevent Ben and Jen from having any contact. Jen is shocked and she speaks up, bravely telling the judge that she does not want a protective order because nothing happened. Then the judge asks her one critical question. If Ben were abusive again, would you call 911? Flustered, upset, and almost on the verge of tears with just anger and overwhelm of the whole situation, Jen replies, rather emotionally, no, because nothing would ever happen. This response raises red flags to the judge. To him, it looks like Jen might be under pressure or afraid to speak honestly. To play it safe, the judge issues a protective order prohibiting Ben from having any contact whatsoever with Jen anyway. The protective order turns their lives upside down. Ben and Jen can't live together, communicate, co-parent their kids, and this creates chaos for their family. A month later, at the second court date, the prosecution offers Ben a plea deal. Plead guilty to a felony domestic violence charge, accept 5 years of probation, and the protective order will be lifted. Feeling like he has no other choice, Ben takes the deal. Now, Ben has a felony, and Jen is left with a husband who has a felony record, and their family's financial and emotional stress has only worsened. Look, even when the victim is on the defendant's side, showing up to a court date and asking for the charges to be dropped rarely helps. In fact, it often hurts. There is a way to prevent this protective order from being issued at the first court date, but it takes an attorney who takes more than 30 seconds just talking to Ben to talk to Ben and Jen and counsel them before court to make sure that if charges are filed and that first court date goes forward, there is not a protective order that prohibits this married couple with little children from being together. If the alleged victim tries to talk to the prosecutor on their own, they are going to be ignored. The prosecution often sees these efforts by the alleged victim as a sign that they're being pressured or manipulated. And then judges, they want to err on the side of caution. Now, as bad as showing up to court unprepared can be, the most dangerous mistake happens when the victim tries to explain, and that's where people think it's harmless or think it's helpful, but that's where most people go wrong. So number one, the victim explains their reason for changing their story. This is one of the most critical mistakes that people make, and it happens all of the time. The victim decides to explain why their story has changed from when they first talked to the police, thinking that it will help, thinking at worst that maybe they will get charged with lying to a police officer. But in a domestic violence case, this can completely sabotage the defense, because here's the problem. Even if the victim does not show up to testify at trial, the prosecution may still be able to use their original statements, like the one that they gave to the police during the arrest. The prosecution will argue that the victim told the truth when the police arrived because they were safe and not under pressure. They'll claim that the victim is only changing their story now because they're being manipulated, or even because they love the defendant too much to let them face the consequences. So if the victim changes their story, and if those initial statements that are bad for the defense come in, the defense has to explain why the original statements shouldn't be believed and why the news story is the truth. But that explanation has to be rock solid. If it's not convincing, then the judge or the jury is going to side with the prosecution's argument that the victim's first statements, the one that are bad for the defendant, were the real ones. Here's what this looks like in real life. Brody and Jody have been drinking. Things get heated and Brody calls the police, claiming that Jody is out of control. When the police arrive, Jody tells them that Brody shoved her, causing her to fall and injure her knees. The police arrest Brody. A few hours later, Jody feels terrible. She bails Brody out of jail and decides to set the record straight. Before the first court date, a police officer calls Jody to follow up, and she explains that this was all a misunderstanding. She tells the officer that she was angry at Brody because of a text she found on his phone, so she lied and said that he pushed her. She also explains that those injuries to her knees, those happened on a different day. Jody thinks that she's helping, but instead she's made things much worse. Now, Prosecutor Steve is reviewing this case before court, and the photos taken by police show that Jody's knees were actively bleeding at the time of the arrest. The officer writes a supplemental report with Jody's new statement and sends it to Prosecutor Steve. Prosecutor Steve reads it, compares it to the original police report, and he decides to file felony charges against Brody. To Prosecutor Steve, this makes her news story look like an obvious attempt to cover for Brody. In Steve's eyes, Jody's second statement proves that she's trying to protect Brody, and the case needs to move forward aggressively. Now, here's the problem. The defense is stuck with two contradictory statements from Jody, which hurts Brody's case. Now look, a big problem with this is the fact that her knees were actively bleeding. That has to be explained, right? If you're the jury and you are looking at this case, or you're even Prosecutor Steve and you're looking at this case, and you see she says, okay, I lied because I was angry at him. Sure, they were in a loud argument. He called the cops. Sure. What about the fact that her knees were actively bleeding? There has to be some sort of explanation for that. But the problem is, and maybe because she was drinking, Jody probably does not remember that her knees were actively bleeding. And so when she makes this statement to the police officer, she thinks that she's covering all of her bases. She thinks she's doing a good thing. But when the defense attorney ultimately gets the file with the initial police report and the supplemental police report with this additional statement from Jody, it makes it much more difficult to come up with, okay, what exactly is our defense here? If Jody is on our side, what is she going to say if she gets on the stand? How is she going to explain this knee injury? It really does look like she is lying to cover up for Brody. Crafting a defense that addresses why a victim changed their story is not that simple, because it requires not reviewing just the police report, which sure, Jody can get on her own before court, but also the body-worn camera footage and any other evidence that the police collect. It also involves an attorney who has deep knowledge of domestic violence case law to predict whether the judge will allow the prosecution to even show those initial statements. The victim just DIYing and adding more statements to the record can easily backfire and make things worse. It's like a defense attorney calling the victim to the stand at trial without prepping them, without talking to them first and making sure that they understand exactly what the victim, and this is assuming that the victim is on the defendant's side, is going to say, and making sure that it fits into their defense strategy. The worst thing that the alleged victim can do for the defense is give a news story like this that doesn't really make sense, that's after that initial interaction with the police, that does not explain all the evidence, maybe because they don't know what all the evidence is at this point, but also because they simply do not have the legal knowledge. And even if they did, even if it were me, I want to have perspective on the situation, which you just cannot have. You are too close when you are involved in the case. Every domestic violence case is unique, but what they all have in common is this: the wrong move at any stage can have devastating consequences. Trying to DIY can easily backfire. It's like me trying to do construction on my office and I knock down a load-bearing wall, maybe because I don't even know that such a thing exists. Or, I don't know, I saw on the internet recently people who are doing DIY lip injections and Botox. How can that go wrong? Let's count the ways, right? It is the same here. It would be better to make no statement than to try to do this on your own. So what should you do? Here's the honest truth. If you have been arrested for domestic violence, you cannot afford to leave your future to chance. You need to hire an experienced, not just criminal defense attorney, but domestic violence defense attorney, someone who understands the system, knows how to dismantle the prosecution's case, and can guide you through this without making costly mistakes because you're trying to do it on your own. The stakes are too high to try to just figure this out by yourself and just sort of wing it. One wrong step really could jeopardize your freedom, your career, and even your family. And just like the alleged victim maybe did not know that you would get arrested and that this would be a train that you can't just get off of whenever you want to, you don't know what you don't know. That's the most dangerous thing with cases like this, where it seems like logically it should go a certain way, but it does not necessarily. So a skilled attorney who does know everything that you need to know in this situation is the difference between getting your life back on track and dealing with the consequences of a conviction for years to come. I hope you found this video helpful. If you do have a criminal case in California, feel free to give me a call. You can find my number down below. You can also book a consultation via the link there. And if you did find it helpful, please don't forget to subscribe, ring the bell, and if you have a question, leave it in a comment.